Advocate Gcaleka is releasing a number of investigation reports. Let's dip into that quickly.
Of the scooter ambulances or clinic within 90 days of the date of issue of this report. The acting head must also ensure that all the officials involved in SCM processes and the senior managers of the department attend a workshop on the relevant legislation and other legal and policy prescripts and instructions of the national and provincial treasuries regulating the procurement of goods and services by the department within 60 days of date of issue of this report. The MEC for Health must oversee to ensure that appropriate steps are taken in respect of disciplinary action in terms of Section 38H of the PFMA and the applicable policies of the department against any decision makers, regardless of position, across all the ranks of seniority that were involved in and responsible for the non-compliance with the provisions of the SCM policy and treasury regulations pertaining to the procurement of the scooter ambulances or clinics within 90 days from the date of issue of this report. In the matter of Anonymous and others versus Eastern Cape MEC for Transport, Safety and Liaison, Provincial Departments of Health and Public Works and Infrastructure, report number 40 of 2020-2021. We investigated allegations of improper conduct and maladministration by the Eastern Cape MEC for Transport, Safety and Liaison, Ms. Weziwe Tikana Qotiwe, and the Provincial Departments of Health and Public Works and Infrastructure relating to the procurement of goods and services. A complaint was launched on 20 May 2020 by an anonymous member of the Eastern Cape Provincial Legislature of the Economic Freedom Fighters Provincial Party, requesting that we investigate the procurement of goods and services by the Eastern Cape Department of Transport, Safety and Liaison from the SITA events and the procurement of accommodation to quarantine COVID-19 patients at Kholeka Lodge. The complainant requested that we investigate the relationship between the MEC, Kholeka Lodge, and Ukhanyo Travels and whether contracts were awarded to these entities due to MEC's influence and relationship with them. On 7 July 2020, the Public Protector South Africa received another joint complaint from Dr. Lwazi Ncapayi of Kalusa and General Bantu Bonke Holomisa MP of the United Democratic Movement in connection with the procurement of accommodation at Kholeka Lodge to quarantine COVID-19 patients. In addition to the request for investigation referred to above, it was alleged that on 15 April 2020, the Provincial Public Works Department, the Provincial Health Department, and the Provincial Executive Council took a decision to accommodate 18 COVID-19 patients at Kholeka Lodge in the Tala Reserve area owned by the daughter of the MEC, which resulted in a conflict of interest on the MEC's part as she was alleged to be the true owner of the Kholeka Lodge and has substantial interest in it. We found that the MEC was not improperly involved with Ukhanyo Travel and Events, SITA Events, Kholeka Lodge, and Vexobite, and did not influence the awarding of tenders to them by provincial government departments. Although the investigation established that Kholeka Lodge and Vexobite are owned by the MEC's daughter and husband respectively, it could not be found from the evidence obtained during the investigation that the MEC was involved or influenced the procurement of Kholeka Lodge as quarantine site for COVID-19 patients. Neither was the evidence which reveals that the MEC influenced the awarding of tenders to Vexobite, SITA Events, and Ukhanyo Travels. No substantive information or evidence for these allegations were provided or could be found. The evidence further reveals that the MEC duly declared a relationship with Kholeka Lodge and her husband declared his relationship with the MEC in respect of the bid submitted to Vexabite, by Vexabite rather. We, however, found that the supply chain management processes followed by the Departments of Health and/or Public Works and Infrastructure when it identified and procured accommodation from Mallorca Lodge for COVID-19 patients to quarantine was in contravention of applicable laws and legal prescripts regulating procurement. To remedy this improper conduct and maladministration, the Provincial Health HOD must take appropriate steps in respect of disciplinary action against the Director for the Chris Hani District of the Department, Ms. N. Kiza, in connection with her role in the irregular procurement of accommodation for COVID-19 patients and the fruitless and wasteful expenditure incurred as a result thereof. This must take place within 60 days from the date of issue of this report. The HOD must take appropriate steps to recover the fruitless and wasteful expenditure incurred by the department in transporting the COVID-19 patients to and from Mallorca Lodge in terms of regulations 9.1 and 12 of the National Treasury Regulations within 60 days of the date of issue of this report. In addition, the Provincial Public Works HOD must take appropriate steps in respect of disciplinary action against the Regional Director for the Chris Hani region of the department, Mr. Gcaleka, for his role in the irregular procurement by the Provincial Public Works Department of accommodation at Mallorca Lodge for COVID-19 patients within 60 days of the date of issue of this report. The HOD must also take appropriate steps to ensure that all the SCM officials of the department attend a workshop on the legislation, regulations, policies, and other relevant prescripts regulating SCM in the department within 60 days from the date of this report. In the matter of Heron versus Madikizela, report number 49 of 2020-2021, we investigated allegations of a breach of the Executive Ethics Code by the member of the Executive Council for Transport and Public Works of the Western Cape Provincial Government, Mr. B. Madikizela. The investigation followed a November 2019 complaint by Mr. B. Heron, a member of the legislature. Mr. Heron alleged that Mr. Madikizela willfully made false and misleading statements to the legislature about him on 23 July 2019, and that conduct in question was improper and constituted a breach of the Executive Ethics Code. We found that MEC Madikizela willfully made false and misleading statements to the legislature about Mr. Brett Heron. The MEC's conduct in this regard constituted a breach of the Executive Ethics Code. As an appropriate remedy, the Premier of the Western Cape must, in terms of Section 3, subsection 6 of the Executive Members' Ethics Act, within a reasonable time, but not later than 14 days after receiving this report, submit a copy thereof and any comments thereon, together with a report on any action taken or to be taken in regard thereto to the Western Cape Provincial Legislature. In the matter of Sithebe Dlamini versus Chris Hani Baragwanath Academic Hospital, report number 46 of 2020-2021, we investigated allegations of maladministration and improper conduct by the Chris Hani Baragwanath Academic Hospital in Gauteng for its failure to inform the Sithebe family of the death of Mr. Themba Milton Sithebe, the subsequent loss of the deceased corpse, as well as the failure by the South African Police Services to investigate or finalize the case of a missing corpse. The investigation stems from a complaint lodged with the Public Protector in October 2018 by Ms. Nokuthula F. Sithebe Dlamini, the deceased niece. We found that there was maladministration and improper conduct on the part of the hospital and its alleged failure to inform the Sithebe family of the death of their family member and the loss of the corpse. However, the allegations that the SABS failed to investigate the case of the missing body of Mr. Sithebe is unsubstantiated. We also found that Ms. Sithebe Dlamini and the family suffered prejudice as a result of the conduct of the hospital. However, the allegation that she or any other person suffered prejudice as a result of the conduct of SABS is not substantiated. As part of appropriate remedial action, the acting head of the Department of Health, Mr. Arnold Lesiba Maladona, and the Chief Executive Officer of the hospital, Dr. Nkele Lisia, must ensure that a register system containing information which expressly indicates the full names and designations of officials at the wards and detailed information regarding who is responsible for patients from entry to the exit of the patient in the wards is put in place. The data register must clearly show a chain of events in the wards: the date, the time, details of patients involved, and all the staff involved in the handling of the patients at the wards. Mr. Malotana and Dr. Lesia must also ensure that the staff is trained on the data on the database of the hospital register, specifically complying with the completion of the register. They must further initiate a disciplinary process against Sister Maile, who was responsible for, among other things, the violation of the Births and Deaths Registration Act, the regulations relating to the management of human remains, and those on the rendering of forensic pathology services. All the above must take place within 60 days of receipt of this report. In addition, they must issue a formal written apology to Ms. Sithebe Dlamini regarding the hospital's failure to inform her about the death of Mr. Sithebe and the subsequent loss of his corpse. This must happen within 30 days of the date of this report. The matter of Belleville Magistrates Court, report number 55, 2020-2021. We investigated allegations of improper conduct and maladministration by the Belleville Magistrates Court relating to an application for a protection order. The investigation followed a June 2020 request by the Deputy Minister of Justice and Correctional Services, Mr. John Jeffrey, MP. The Deputy Minister requested that we investigate allegations reported in the news media that Ms. Altasia Korcha approached the court to apply for a protection order, but was turned away by the court officials. According to the media reports, Ms. Korcha was allegedly murdered by her former partner on 12 June 2020. In essence, it was alleged that the failure by the officials at the court to assist Ms. Korcha with her application for a protection order was improper, constitutes maladministration, and prejudiced her and her family. From the evidence obtained during the investigation, it is concluded that the late Ms. Korcha visited the court around midday on the 8th of June 2020 to apply for a protection order in terms of the Domestic Violence Act. Her name was placed on the list of complaints at the protection order section of the court. She was attended to by a clerk who provided the application form to her to complete and provided her with an explanation in connection with her application, the involvement of social workers, and that the respondent would have to appear in court. According to the evidence of the two senior administrative clerks that were on duty on the day at the protection order section on 8 June 2020, they could not specifically remember the late Ms. Korcha, but they followed the same procedure in respect of applications for protection order as they do on the ordinary course of their duties. It was also evident from the records of the court that several applications were processed on the 8th of June 2020 and the interim protection orders issued. Ms. Korche left the court about an hour after her arrival without having completed and submitted the application form for further assistance. Her explanation to Ms. N.G. Dove, who had accompanied her to the court on that day, was that she did not expect that it would be a long process to obtain the protection order, and there was too much to write. It was not clear whether Ms. Korche intended to complete the form and return it to the court with her application. According to her mother, the late Ms. Korche had to go to work the next day and did not return home on 10 June 2020. She was later found deceased. There is no evidence indicating that Ms. Korche was turned away by the court when she wanted to apply for the protection order. The evidence shows that she was assisted at the protection order section and requested to complete the prescribed application form. She also did not indicate to Ms. Dove or her parents that she was not assisted by the officials at the court to complete the application process. It could not be established with certainty why Ms. Korche decided not to wait to be assisted with submitting application after having completed the form, but to return home. The evidence obtained from the investigation does not support the allegations that Ms. Korche was turned away or not assisted by the Bellville Magistrates Court. When she wanted to apply for the protection order on the 8th of June 2020, there was thus no improper conduct or maladministration on the part of the court. However, this morning we visited the family of Ms. Korche in Delft, not far from where we are. We communicated to them the contents of this report and assured the family that the tragic passing of Ms. Korche and her daughter, Renasia, has spurred us on to take up the cudgels on behalf of all other victims of gender-based violence in society. I shall later dwell on this. As I conclude on investigation reports, the office looks forward to the full implementation of the appropriate remedial action taken in respect of the above investigations. Accordingly, we would like to remind all the affected organs of state that today marks 5 years since the Constitutional Court handed down the Economic Freedom Fighters versus the Speaker of the National Assembly judgment. As you will recall, in that seminal ruling, the Constitutional Court held that the remedial action taken by the Public Protector is binding unless set aside by a court of law. Of relevance in this regard is the following passage in the judgment. I quote, "When remedial action is binding, compliance is not optional. Whatever reservations the affected party might have about its fairness, appropriateness, or unlawfulness, for this reason, the remedial action taken against those under investigation cannot be ignored without any legal consequences." I unquote. Full copies of the report in respect of each of these matters can be accessed on the Public Protector South Africa website. In addition, all the affected and interested parties have been furnished with copies. As we prepare to begin the 2021-2022 financial year, which commences tomorrow, our approach is to be developmental in our work and optimize our impact in ensuring a strengthened governance system to build a capable state. One of the key projects for the year is a systemic investigation in honor of Ms. Korche, her daughter Renaisia, and many other victims of gender-based violence across the country. It will be a nationwide investigation into the systemic challenges that plague the justice value chain to fight gender-based violence. That will be one part of the investigation. The other part will look into the systemic challenges pertaining to child maintenance, which is also a cause of concern. We have previously dealt successfully with a case of a distraught young mother in this province who struggled with child maintenance, even though the courts had ruled that areas and future maintenance benefits be deducted from the defaulting father's pension fund. The child maintenance aspect of the investigation was also inspired by a cry for help which we came across on a Facebook post. In the post concerned, another distressed mother laid bare her maintenance court experience, demonstrating how women and children experience secondary victimization in the system and how humiliating the process is. The post read in part, I quote, "I decided to set up office here and arrived just after 7 a.m. They open at 7:45 a.m.
That was Acting Public Protector Advocate Gcaleka releasing a number of reports from the Public Protector's Office. We're going to take a quick ad break and we'll be back with more news.